Thank you. Good morning and welcome to the 29th meeting of Session 6 of the Equalities, Human Rights and Civil Justice Committee, with no apologies this morning. We're joined today by the Cabinet Secretary for Social Justice, Housing and Local Government, Shona Robertson, MSP and Scottish Government officials. We're also joined by a number of MSPs who have lodged amendments at Stage 2, and others may join us throughout the meeting. We also have a full public gallery. I would like to welcome everyone who's participating in the meeting today and to those who are observing either here in person or online. We have a large number of amendments to consider and dispose of for this bill. The committee has scheduled 2 days to do this, and I intend to allow as much debate as is needed for each amendment. However, I would ask members to be as concise as possible and keep their points to what the amendments are about. If we do not make sufficient progress, the committee may require a third day, and should this be the case, I will discuss that with members, and if necessary, will approach the Parliamentary Bureau to request that the Stage 2 deadline be extended. We're also expecting a long session this morning, so I will pause proceedings to allow for comfort breaks at appropriate points. So our sole agenda item today is Stage 2 consideration of the Gender Recognition Reform Scotland Bill. Members should have a copy of the marshalled list and groupings. If votes are required today, I will call for members to vote yes first, and then for members to vote no, and then any abstentions. Members should do so by raising their hand, and clerks will collate the vote and pass them to me to read out and confirm the results. Can I remind Cabinet Secretary's officials that they cannot speak during this stage, but are allowed to communicate with the Cabinet Secretary directly. Members with amendments in a group will be called in turn. If any other member wishes to speak, please indicate and I'll make every effort to accommodate. So, we'll make a start. So there are no amendments to Section 1. So the first question is that Section 1 be agreed to. Are we all agreed? That is agreed. I call Amendment 18 in the name of Rachel Hamilton, grouped with amendments as shown in the groupings. I draw members' attention to the procedural information relating to this group as set out in the groupings. Point out that if Amendment 42 is agreed to, I cannot call Amendment 19 due to preemption. So Rachel Hamilton to move Amendment 18 and speak to all amendments in the group.
Thank you, Convener. The bill as drafted will extend the ability to obtain legal gender recognition to 16 and 17-year-olds. My amendments seek to retain the current minimum age required to apply for a GRC at 18 based on a statutory declaration without any form of medical oversight. My concerns and the concerns of my colleagues relate to lowering the age below 18 in Scotland. I recognise that 16 is the age of legal capacity in Scotland, but also conversely that higher age limits apply for several matters that are of less significance than changing legal sex, such as purchasing alcohol, cigarettes, getting a tattoo and driving a car. Recently, the Scottish Government sought to incorporate the UN Convention of the Rights of the Child, otherwise known as the UNCRC, into domestic law, which defines anyone under the age of 18 as a child. And according to Susan Smith from FWS, people do not cognitively mature until 25. Using comparisons in other countries who have taken a more conservative approach to the age limit to apply for a GRC, in Denmark, one must be 18 to legally change gender, whereas in countries such as Belgium and Argentina, parental consent is required for those under the age of 18. Furthermore, the Scottish Government are pursuing an inconsistent approach when defining maturity. Scottish sentencing guidelines refer to the sentencing of those under 25, claiming that they are not cognitively developed and have a lower level of maturity and a greater capacity for change. According to the EHRC, this change increases the likelihood that trans pupils with GRCs are present in educational establishments in Scotland. This has implications for the operation of the education provisions of the Equality Act. Its specific exceptions to the direct discrimination for education providers would not apply in the same way as they do now, because people under the age of 18 cannot currently obtain a GRC. At present, the law allows schools to take a proportionate approach to balancing the needs of trans pupils with those of other pupils. The changes proposed in the bill may require educational establishments in Scotland to treat trans people with a GRC as having their acquired gender for all purposes, including in a single-sex school, leaving the school potentially open to direct discrimination claims if it sought to balance the needs of trans and other pupils. I would welcome if the Minister could provide clarity on this point as to what the position for single-sex schools would be should this bill pass unamended. The Scottish Government have dismissed the findings of Dr Hilary Cass's interim review as not relevant to Scotland, which is contrary to the stance taken by the First Minister to compare NHS England with NHS Scotland when answering questions at First Minister's questions. We share the view of stakeholders that it is prudent to wait until the final conclusions and recommendations of the CAST review before moving to make legal gender recognition available to 16 and 17-year-olds in Scotland. The Scottish Government, I believe, fails to recognise that providing a route to a change of status in law is a form of social transition and therefore is not a neutral undertaking. The Scottish Government and the majority of the committee appear determined to deny any risk that affirming a young person's self-declared gender identity may encourage them onto a medicalised pathway in a setting where the evidence base is lacking. Given the stakes here, every law we make must be supported by robust analysis. We think there are hard questions about Scotland's gender identity services for young people, especially considering the lack of robust data on clinical outcomes. In the absence of better information about the cohort of 16 and 17-year-olds experiencing gender incongruence, MSPs are being asked to make a very significant decision affecting a vulnerable group, based largely on some young people's strongly and no doubt genuinely expressed desires, and the amplification of those by adults strongly committed in principle to an affirmation-based approach. The basis appears shaky for assuming decisions here will have no spillover effect on NHS services and that any legal risks emerging there can be ignored. It does look unreasonable that MSP should decide that NHS Scotland needs time to consider the final CAST review recommendations before lowering the age for a GRC is considered. As the Bayswater Support Group for Parents has put it, our children deserve the same level of care and safeguarding as their English counterparts, and it is incumbent on our lawmakers to consider the needs of vulnerable young people when considering this bill. I urge members of the committee to consider the crystal clear arguments I have presented today and support the retention of the current minimum age of 18 required to apply for a GRC. I move Amendment 18 in my name.
Thank you. And now move online to Carol Mochan to speak to Amendment 117 and other amendments in the group.
Thank you, Convener. Primarily, I am raising Amendment 117 to reflect the numerous expressions of concern I, and no doubt many others, have received regarding the content of this bill. Whilst I do agree that many people are in favour of the spirit and intent, there are details which have been overlooked regarding the practicalities and protections of getting gender recognition certificate for younger people in particular. Given the Government have expressed that it considers the minimum age for applying for legal gender recognition should be reduced to 16, it is my view that should the legislation pass, there must be extra provision in place to support 16 and 17-year-olds, and they must be able to request this should they make this decision. Many young people will be reaching a time of change in their lives, becoming independent, moving away from home, beginning full-time work or starting university or college courses. For that reason, it would be preferable that a young person seeking to support to obtain a gender recognition certificate had guaranteed access to confidential quality support. Similarly, many, particularly of the youngest in this age group, are very likely to be living at home and may experience difficulty communicating the decision to direct family, leading to a sense of isolation and helplessness. This is well documented within the evidence collected. This can be assisted with free and accessible advice that helps young people to understand the practicalities of the decision and their options for the path ahead. It may give the young person support to talk, work with their family at a stage that is most helpful to them. Where challenges exist, this support could come in the form of a family liaison officer who could assist with communication. In all cases, there also ought to be well-being support available from a professional and trusted source to protect the mental health and well-being of young people who request such support during this process. I would ask the Cabinet Secretary to set out the Government's position on these points that I have raised in this 117 amendment in her remarks. This support must be universal and confidential if it is to succeed, but I feel it is absolutely necessary to help young people during a period of particular need. The amendment would give reassurance to young people and their families that there is balanced, universal support available should it be required, and any support would have to be would have the young person at its focus. And I move 117 in my name. Thank you, Convener.
Thank you. Christine Graham to speak to Amendment 38 and other amendments in the group.
I'm not sure whether you want me to move at the beginning. But
no, move later.
Well, there, I'm told already. Right. I was actually I rise to speak, well, I'm not rising anyway. I speak to Amendments 38, 39, 40, 41, 42, 43, 44, 46, all in my name. My amendments are supported by Jackson Carlaw. The intention of these amendments is to ensure that before applying, 16 and 17-year-olds have made use of the opportunity to take advice, guidance or support in making the decision, including considering the implications of getting a GRC. And this refers actually to a later amendment, which I'll come to, about what the Registrar must publish. This is mandatory. The provision is not overly restrictive and requires that they confirm to the Registrar General that they have discussed this either with an adult they know personally, for example, a supportive family member or friend of the family, or with someone who has a role that involves giving guidance, advice or support to young people, for example, a teacher, a counsellor, a suitable service such as the doctor, guardian, LGBT youth. There's a whole range. The form of this confirmation is also not restricted in the amendments to allow for flexibility in individual circumstances. I'm not naming a list. The Cabinet Secretary has already undertaken that 16 and 17-year-olds will be offered and encouraged to take up a conversation with National Records of Scotland about the process and effect of a GRC. It is important that wherever possible, the confirmation should be part of such a conversation, which would take place during the reflection period, and invite the Cabinet Secretary to confirm whether she agrees with that approach or indeed with my amendment. The offence in the bill of making a false application does not apply to this confirmation. There is no desire to criminalise 16 and 17-year-olds or require them to provide proof. I'm going to say that, if I may then refer to the amendment Carol Moughlin's name, which tries to do much of the same thing. However, I feel it's rather heavy-handed. It's putting in law unnecessary support service for application. They all exist just now. And the Registrar General must confirm that the person has actually taken this advice, and they make that mandatory, taken it as a mandatory thing, and it puts the onus on them, because this is a big decision for them. These advice supports are already there, so I really, if you'll forgive me saying, I don't think it's necessary for your amendment, and mine is the better one, but then I would say that. Speaking to 42-43, the intention of these amendments is to extend the minimum period of living in the acquired gender before application from 3 months to 6 months. And I do understand Rachel Hamilton's concerns, and that's why I'm putting in these other precautions for that particular age range, specifically for 16 and 17-year-old applicants. But that's the very least of it. They might take longer, and so might 18-year-olds. They do this by either by introducing two options into the required statute declaration. Either an applicant must state that they are 18 or over and have lived in their required gender for at least 3 months, or that they are 16 or 17 and have lived in the required gender for at least 6 months. This will provide additional assurance that these applicants have had time to fully understand the change they are making and to be confident that they really do want to live the rest of their life in their acquired gender. This will not introduce an additional delay for someone who's already been living in the required gender for at least 6 months. They could still apply on their 16th birthday because they will have done it well ahead of being 16, and after the 3-month reflection period could obtain a GRC. Never let's forget there's a reflection period thereafter. I think I make a passing reference to the amendments to Martin Whitfield and in 120, 124. 120, I think, is just a consequential. My other ones are consequentials. We're not in collusion, by the way, just sitting next to each other by mistake. I think my amendments, again, if I can be modest, would be better. I say put the onus on the young person to specifically confirm they've discussed their application and understand that. It's a big decision for them, so it's making them sure that the onus is on them to have done this. And I believe that is a better approach than Martin Whitfield's amendments, which puts this on the Registrar General to satisfy himself the applicant has capacity to understand. Capacity is a difficult word in law. I don't know whether it means legal capacity, what kind of capacity. There is a discussion with the Registrar that will take place. It can take place face-to-face or online or whatever. And that's the time when the Registrar can decide whether or not this person really understands what they're doing. I think the word capacity is a difficult word to use in law. Perhaps he should have put in fully understand what they are proceeding to do. But he didn't put that in. That's why I don't like his amendment.
Okay. Thank you. And Karen Adam.
I think I've spoken to them all, haven't I? Yes.
Yes. Karen
There's
Adam.
so many.
Thank you, Convener. I thank Christine Graham for her amendments, and you know, you were talking there at the beginning how you have support from Jackson Carlaw. So I was just wondering, in terms of your amendments, what kind of support have you had for these in conversations with other colleagues?
Strangely enough, I don't know. I haven't gone around lobbying for them. I think they're all intelligent people in this Parliament, hopefully, and they can see the amendments and see. And I laid the ground during stage one. And what I was intended to do is to put precautions and support for the 16 and 17-year-olds, because I did share concerns that they were being put in the same boat as the 18-year-olds. So I'm really, the test is on this committee. You've been doing this in depth, so I'm hopeful that this has hit fertile ground.
Okay, thank you. And Martin Whitfield to speak to Amendment 120 and other amendments in the group.
I'm very grateful, Convener, and it is always a pleasure to follow Christine Graham, even when she seeks to perhaps insult my poor amendment. I intend to speak to 124 and 120. 120 is a technical amendment for it to fit in. If I deal first with the purposes behind this amendment, the Registrar-General will have an important role, or the Registrar will have an important role in this process if it moves forward. And the purpose behind these amendments is really to draw out, and I would seek the view of the Cabinet Secretary on this, that our young people who are 16 and 17 have protections that exist around them anyway, and they are quite substantial. It is a transitional period between childhood and adulthood where we seek to allow our young people as much freedom as possible while still providing scaffolding support should things go wrong or should perhaps decisions be contrary to the interests of an individual. The reason, to answer Christine Graham's why I picked, in respect of the Registrar-General, on which to place really the obligation to ensure there is some protection there, is because this is someone who already undertakes statutory requirements, undertakes assessments made by people who present themselves throughout a variety of our legislation, and I think is well capable of making those decisions. And the protections that are extended in respect of this case are really very narrow. The first two contained in 2BA is the effect of obtaining the certificate and the importance of a statutory declaration. Well, anyone who undertakes to hear a statutory declaration needs to ensure themselves that the understanding of the significance and importance of that document is made. And the effect of obtaining this certificate is to allow the registrar to ask those questions to satisfy themselves that this person is fully understanding of the consequences of it. And then Section B is the very important one, to ensure that the application has not been made under coercion. We echo this in a number of other matters. I think of a marriage situation where there is a requirement on the person registering that to ensure that no coercion has taken place. With regard to the discussion as to capacity, it carries a very strict legal definition. But the capacity is the word that defines that position a young person is in to make such a significant and important decision in respect of these matters. So both amendments, mainly in 124, really seek to remind a registrar of the legal obligations that already exist upon a registrar, but also to allow them in certain situations to avail themselves of the ability to say no, but on the basis that the availability and decision would always be yes. Unless I can guide any further anyone, I'm happy to leave it at that.
Okay, thank you. And Maggie Chapman.
Thanks very much, Joe. I want to speak generally about the amendments in this group. First thing I want to be clear about is that in Scots law, the age of legal capacity is 16. At this age, young people can get married, join the army, work, vote in Scottish parliamentary and vote in local elections. It's almost as if we trust them to make big life decisions on their own. I don't see why this is any different. Let us also remember that many young people have already socially transitioned, which might include coming out to friends and families without applying for a GRC. Not having a birth certificate that matches their identity could cause issues when applying for jobs, further or higher education, and more importantly, leave them open to a lack of privacy regarding their trans status. I am vehemently opposed to the current time periods, both the living in the acquired gender periods and the reflection periods. They are not based on specific evidence, and they fall short of international best practice for gender recognition, which has no waiting periods at all. Therefore, making the 3-month living in the acquired gender period even longer for 16 and 17-year-olds simply increases the length of time they may have documents that disclose their gender history without providing any clear benefit. It also risks there being more opportunities for those who do not agree with a young person's decision to apply for a GRC to go digging through that young person's online presence for misgendering, use of a different name, and so on. Young people tend to express themselves in a much more gender-fluid way than others, and the longer time period puts them at greater risk of bad faith actors. I would ask how many young trans people the members supporting these amendments have actually spoken to in drafting their amendments. If they had done so, I'm not sure we would be here debating them. So I will be voting against all of the amendments in this group.
Thank you. Pam Duncan-Glancy.
Thank you, Convener, and I thank the members who have put forward their amendments this morning. Convener, I'd like to speak to a couple of amendments in this group. In short, I think there are merits in many of the amendments we have before us in this section, and I have some concerns about aspects of some of them too. And so I hope, therefore, that we might work together ahead of stage 3 to bring some of these back. Carol Mochan's amendment, as she has already highlighted, seeks to address the concerns that some people have. It would require the provision of free, confidential and balanced support to be available for 16 and 17-year-olds applying for a GRC at their request. For some people, this would be really important. And Carol Mochan's amendment seeks to ensure there is support there for people who need it. This amendment would give 16 and 17-year-old applicants the opportunity to access it on their terms. This is a positive way to support young trans people to access their rights and is distinct from other amendments in this group, and in particular the amendment in my colleague Christine Graham's name. And so on that basis, if those amendments were pressed, I would need to abstain. Martin Whitfield's amendment would add coercion of 16 and 17-year-olds as a factor to reject an application, and that there is a presumption that 16 and 17-year-olds do have the capacity to understand the process. All of these elements, support, capacity and the influence of coercion, as my colleague Martin Whitfield has highlighted, I believe could be helpful and I think should be considered further at stage 3, and I would urge the Government to continue to work with my colleague to do that. Convener, I'm afraid I can't support amendment number 31 in Rachel Hamilton's name because it delays the Act and trans people have already waited long enough for reform. Thank you.
Thank you. And Fulton McGregor.
Thanks, Convener. Just very briefly, I think it's fair to say that this was a particular area that we heard quite a lot about during stage 1. And we heard varying views, and therefore I'm not surprised at the number of amendments that have came forward. I think perhaps the views of all the two sides of the argument, if you like, have already been expressed quite well, summed up by Rachel Hamilton, perhaps, in one respect, and then Maggie Chapman in another. But I think that, and we heard during the stage 1 debate that as we move forward through stage 2 and stage 3, we're wanting to build consensus around this bill. And I think that, therefore, this is an area where we should try to do that. And we've heard the Government say that, and the Cabinet Secretary has referred to this particular issue around 16 to 18-year-olds as being one of the most difficult decisions in taking the bill forward. So, based on what I've heard today so far, I'm not sure who's going to press and who's going to take it forward to stage 3, but I would be inclined at this stage to suggest that Christine Graham's amendments find that balance, and based on that, I would be inclined to vote for them at this stage, Convener.
Okay, thank you. And Cabinet Secretary.
Thanks, Convener. In their stage 1 report, the majority of the committee agreed that the age of eligibility for applicants should be 16, and the principles of the bill had support from members of all parties and were overwhelmingly supported by Parliament at stage 1. The committee has heard from young trans people, as have I, that they currently feel excluded from the system, particularly at an age where they want consistent documentation before entering higher or further education or starting their first job. Therefore, I cannot support Rachel Hamilton's amendments, which are contrary to the general principles of the bill. I've heard the views of members across the Chamber in relation to the need to ensure that young people receive guidance and support in making an application.
I'm unable to support Amendment 117 in the name of Carol Mochan. It's unclear to me what the provision of balanced support might be in relation to a young person's application for a GRC, nor am I convinced that it's beneficial to mandate in law the establishment of a wide-ranging support service for young people, specifically in relation to making an application for a GRC. I consider this approach would be disproportionate given the very small numbers we anticipate would apply in comparison with the general population. Support options already exist, and we will ensure that young people are provided with guidance on their application and can access wider support. I note from a number of equality organisations that, while understandably and rightly supporting the general spirit of improving support for young people, do not think this provision needs to be in legislation. And as such, I would ask the committee to not support this amendment. I believe the principles of what Carol Mochan is trying to achieve, however, are provided by Christine Graham's amendments in this group. These take a balanced and proportionate approach to this issue, and I support them all. These additional safeguards for young people provide the reassurance that MSPs have said they want around lowering the minimum age of application. A minimum age of 16 for applying for legal gender recognition aligns with the provisions in the Age of Legal Capacity Scotland Act 1991, where under Scots law a person of or over the age of 16 generally has legal capacity to enter into transactions having legal effect. However, concerns have been raised with me by MSPs about striking the balance between autonomy and protection of young people. I'm grateful to Christine Graham for speaking with me about this matter, and I agree that increasing the minimum period of time for applicants aged 16 and 17 from 3 months to 6 months would address concerns that have been raised while not placing a disproportionate barrier on young people seeking to apply. We know that applying for legal gender recognition is often the end of a process whereby people made changes to their gender on official documents, and where a young person has already been living in their acquired gender for a minimum of 6 months, they can affirm this in their statutory declaration, so no additional delay would be involved for those young people. Increasing the period of time to 6 months would also give young people greater opportunity to access support, advice or guidance before applying, which they can then confirm to the Registrar General. Amendments 120 and 124 in the name of Martin Whitfield, while possibly well-intentioned, do put the emphasis, in my opinion, in the wrong place. Christine Graham's amendments place a requirement on the young person seeking to make an application to actively confirm that to the Registrar General, that they can discuss the implications of their application with a suitable third party, and I think that's a reasonable expectation. Martin Whitfield's amendments, however, place the onus on the Registrar General to satisfy himself or herself that the applicant has capacity to understand and is not being coerced. And as he said in his evidence to the committee, it's not for the Registrar General to be making such determinations, but my own Amendment 60 does give the Registrar General the power to apply to a sheriff in order to refuse an application on the grounds that the application was fraudulent or that the applicant is incapable of understanding the effects of obtaining a GRC or of validly making the application before issuing the certificate. It is appropriate that such decisions be made by a sheriff on the basis of evidence taken by them rather than on the judgment of the Registrar General. For these reasons, I would ask the committee not to support Martin Whitfield's amendments and to support all those in the name of Christine Graham. Finally, turning to Amendment 31 in the name of Rachel Hamilton, I'll again reiterate my position that there is no connection between the outcome of the CAS review of NHS England services and this bill, which is about the process to obtain legal gender recognition in Scotland. I see no reason why the commencement of the substantive provisions of the bill should be delayed. As the Scottish Government has continued to state, we will closely consider the findings of the CAS review in the context of our work to improve NHS Scotland services, and this is also backed up by the evidence heard by committee members during stage 1, and therefore I urge the committee not to support Amendment 31. Just for completeness on Rachel Hamilton's comment on education, The bill doesn't modify the education provisions in the Equality Act on the requirements for schools not to discriminate in providing education and offering places in schools. Extending the effect of a GRC to 16 and 17-year-olds doesn't change the education provisions in the Equality Act, and the bill does not modify the effects of a GRC. Protection in the 2010 Act will continue to apply to all children and young people, and the arrangements for recognising their transition will remain the same within schools. Thanks, Keith.
Thank you. Now, Rachel Hamilton to wind up and press or withdraw Amendment 18.
Thank you, Convener. Whilst I understand the motive for Carol Mocken's amendment to try to implement a safeguard in the process, we will not support, as we cannot envisage that the NHS services or otherwise will miraculously improve, especially because the Scottish Government's reform to self-identity will open up a wider group of people, therefore putting more pressure on our medical services and other services included in Carol Mocken's amendment. Christine Graham's amendment is creative but ill thought through. How can we, as elected members to this place, guarantee that young people who are at vulnerable age genuinely receive the support that they need? I'm disappointed that the Scottish Government are attempting to use young people as collateral damage to water down the bill, to appease their own SNP rebels. I'm disillusioned by the sceptical approach by the Cabinet Secretary. The CAS review is a key piece of work, and therefore the Cabinet Secretary has not taken heed of the interim review. But I agree that moving forward we should consider what the full review says. And living in acquired gender for at least 3 months is an arbitrary figure, just like the 3-month figure plucked from nowhere without evidence. Martin Whitfield's amendment is flawed because it presumes that the Registrar General has the ability to determine capacity, something that was never explored during the evidence suggestion regarding the conversation around statutory declaration. However, on a positive note, I welcome Fulton McGregor and Pam Duncan-Glancy's offer to work together in the future.
Thank you.
And I move, I press.
Press. Thank you. So the question is that Amendment 18 be agreed to. Are we all agreed? No, we are not agreed. So therefore the question is, so we go to a vote. All members who wish to vote yes, please raise your hands. All members who wish to vote no, please raise your hand. Okay. All abstentions? And there's one abstention. So 2 members voted yes, 4 members voted no, and there were 1 abstention. The amendment is therefore not agreed. So I call Amendment 114 in the name of Russell Finlay, group with amendments as shown in the groupings. Russell Finlay to move Amendment 114 and speak to all amendments in the group.
Thank you, Convener. Let's start with what should be a statement of the obvious. My opposition to this bill as it stands has nothing to do with the rights of those who identify as transgender. These 8 amendments in my name are not directed towards trans people. These amendments are to do with criminals, male criminals who use lies, cunning and deception to commit and to get away with serious wrongdoing, male criminals who commit serious crimes, especially acts of sexual violence, male criminals whose victims are almost always women and girls. The overarching purpose of my amendments are to ensure that if this bill is passed, it will contain vital public safeguards. I will address my amendments in numerical order, and given the constraints that have been imposed at stage 2, I'm mindful of my limited time and intend to be concise. The 8 amendments are grouped under the heading Applicants with Criminal Charges or Convictions. The first, number 114, would prohibit anyone on the Sex Offenders Register from being able to acquire a gender recognition certificate. GRCs on the basis of self-identification should not be available to those who have been convicted of sexual offences of a seriousness requiring their inclusion on the register. As it stands, the bill would allow a registered sex offender to change gender and thereby acquire a new birth certificate, and which would hide their true identity. This would make it incredibly easy for predators to erase their pasts. Society would be prohibited from any way of knowing if a legally defined female was actually a male sex offender. Prisons are full of men who exploit whatever mechanism or loophole is available to gain access to women and girls and to commit sexual offences. The GRR bill would be a gift to such predators. It would increase public risk, that risk predominantly being towards women. Amendment 118 is a consequential of number 125, while 119 is a consequential to 142. I'll come on to 125 and 124 later. Next is Amendment 123, which would require GRC applicants to disclose criminal convictions. I believe it's proper for an applicant's criminal offending history to be taken into consideration, given that the safeguard of a medical diagnosis is not in this bill. However, as things stand, and as I understand it, gaps in the bill mean we don't know how this amendment would work in practice. Specifically, it's not yet known who these proposed disclosures would need to be made to. We therefore need more information from the Government, and I look forward to the Minister's response. However, I hope that she agrees that those deciding on GRCs would benefit from being as fully informed as possible. This Amendment 123 would help to achieve that. Amendment 125 is in some ways an extension of number 123. This would require any GRC applicant to disclose convictions for various crimes, those being sexual offences, violence, domestic abuse and fraud. The same requirement would apply to those who are on the Children's Barred List, a database of those who are unsuitable to work with children. This amendment would also require all such applicants to provide evidence of gender dysphoria in their GRC application. The Registrar-General for Scotland would not be able to issue a GRC unless the applicant provided authentic evidence. I am aware that some of the measures in 123 and 125 are not in place under current law, but that is because they are not necessary given the other safeguards that currently exist. These include the need for a medical diagnosis when applying for a GRC, and that you must have lived in your acquired gender for 2 years. It's in the interests of public safety that extra care and scrutiny should be taken in respect of those with such serious convictions and those unfit to work with children. I note that yesterday the Equality and Human Rights Commission highlighted a lack of clarity about the use of the bill's phrase, quote, living in the acquired gender. The EHRC duly recommend that amendments, including this one, should be considered to improve, again quoting, precision and workability. I turn to Amendment 127. This would stop a GRC application where an applicant is charged with any crimes being prosecuted under solemn proceedings. The bill would allow people to change. The bill as stands would allow people to change gender after just 3 months. We know that most, if not all, solemn cases, that is, sheriff and jury trials and high court trials, typically take much longer than 3 months to proceed. Therefore, an alleged rapist would be able to seek a GRC before coming to trial. In such circumstances, we would achieve the ludicrous situation where a rape victim may have to refer to her male-bodied rapist in the dock as she and her. It is worth noting that the Sexual Offences Scotland Act 2009 states that rape is when someone, without consent, penetrates another person's vagina, anus or mouth with their penis. On December 15 last year, the Criminal Justice Committee took evidence from Justice Secretary Keith Brown and a Police Scotland Deputy Chief Constable. I asked whether a female rape victim might be required in court to use the pronouns she and her for a male rapist. The answer was unclear. I asked whether the police would inform a victim if a rapist changed gender before standing trial. The answer was unclear. I also asked if media reports of Police Scotland already recording the sex of criminals based on their self-declaration were accurate. The answer to that appeared to be yes. Mr Brown told me that he does not control the courts. That may be so, but the courts will be obliged to adhere to this bill. The consequences will surely be that a male rapist with a penis could legally be a she. He added, and I quote, that nothing in the proposed gender recognition reforms should impinge on this area. Convener, I fail to see how that can be. He went on to say that courts, prisons and the police are, and again quote, very cognisant of the rights and safety of individuals. But whose rights prevail? Those of a female rape victim or those of a male who can exploit the ease of acquiring a GRC. This is absurd, and I believe most reasonable people would agree. It risks making a mockery of the justice system and re-traumatising victims of sexual violence. This amendment, 127, is therefore as obvious as it is vital. My next amendment is 129. This would require the Registrar-General to inform Police Scotland whenever anyone with a criminal record is granted a GRC. This would preclude those whose convictions are spent. I believe it's in the interests of public safety and the police's ability to detect crime for them to be made aware when GRCs are issued to convicted criminals, as they would have no other way of knowing under the terms of the bill as drafted. This is especially so with certain types of crime, including sexual offences and fraud. Some sex offenders will almost certainly seek a self-declaratory GRC as a means to reoffend by gaining access to single-sex spaces. More generally, and as touched upon earlier in my submission, it's likely that some will attempt to erase their offending history by acquiring a GRC. Convener, I was surprised and concerned to learn that more than 500 registered sex offenders in Scotland have recently been allowed to change their names. I would rather that was not the case, that they can do this, but that would require a change in law that can perhaps be discussed another day. But at least the police must be informed when this happens. It would be logical and consistent for them to also be informed when offenders are issued a GRC. I now move on to my final amendment, number 131. This would allow a sheriff or judge to revoke a GRC of someone who was later convicted of rape or another sex crime. As stated in relation to Amendment 127, the legal definition of the act of rape states that it can only be conducted with male genitalia. If a man commits rape or sexual assault, it would be an affront for the law and an insult to victims to continue to categorise him as female. Many of these amendments are common sense. We cannot allow Scotland's criminal justice system to be undermined by ill-conceived legislation which has the most profound of consequences. The effects of this bill will ripple through the police, prosecution, prison and courts. Unchecked, it could harm crime victims, enable criminals and skew crime statistics by rendering the recording of sex to be effectively meaningless. The prime purpose of my amendments are public safety and the preservation of the rights of women and girls who may fall victim to sexual violence. I move 114 and I urge members to give them their support.
Okay, thank you. And Cabinet Secretary.
Thanks, Convener. I want to be very clear from the start that the real threat to women and girls is predatory and abusive men. Unfortunately, as around the globe, we live in a society where men in the home and outside of it are the perpetrators of violence against women and girls, and this must, of course, be tackled. There's no evidence, however, that those men would obtain a GRC in order to abuse women, or that this has happened in any other countries with similar processes. I recognise that some people have concerns and fears that are genuinely held, and we should seek to address those concerns. But concerns about the behaviour of abusive and predatory men should not mean, of course, that we impinge on the rights of trans people. And while I understand the concerns people have about abusive men, the bill takes the exact same approach as the current system, where none of those restrictions apply to people who have committed certain offences. This group of amendments would prevent people who have committed certain offences from applying for or receiving a GRC, would pause applications for people charged with certain offences, or would introduce reporting requirements relating to certain convictions. I mean, anyone with any criminal convictions at all, no matter what, would need to declare that. Amendment 123 does not exclude spent offences, and it is not clear how it could be checked by the Registrar-General. Amendments 125 and 118 would reintroduce the need to show gender dysphoria for some offenders. The Scottish Government considers Amendment 114 is likely to be clearly out with legislative competence as incompatible with Article 8 of the European Convention on Human Rights. A further difficulty is that the ban would depend on when those requirements are imposed. In one case, the requirements could be just about to elapse when an application for a GRC is made. In another, the ban on being able to obtain a GRC could last for a considerable number of years. Similarly, Amendments 127 and 119 would also be incompatible with Article 8 of ECHR and possibly also Article 14 because they differentiate between persons based on the procedure attaching to the charge for the offence in a way that cannot be justified. It also has the same difficulty as Amendment 114 in relation to the timing when the notification requirements are imposed. The Scottish Government considers that, for similar reasons, Amendment 131 is likely to be out with legislative competence as it's incompatible with Article 8 of ECHR and possibly also Article 14 because it differentiates between persons based on the type of offence committed. Again, no such restrictions are part of the current system under the UK Government, which also must comply with ECHR. To be clear, inserting provisions into this bill that are incompatible with the European Convention of Human Rights puts implementation of the bill in jeopardy. It brings the risk of legal challenge before the new process could be put in place, and if successful, that would prevent implementation until the compatibility issues were resolved through primary legislation. Convener, the bill already provides for a person who has an interest in a GRC to apply to the Sheriff to revoke a certificate on the ground that the application was fraudulent. However, we have listened to the concerns some members have raised about the possibility of sex offenders seeking to take advantage of the proposed processes for gender recognition. And while we think the processes for sex offender notification requirements are working well, there is an existing legislative power Scottish ministers have to vary the information provided at notification. I can today inform the committee that the Cabinet Secretary for Justice and Veterans will, before this bill is commenced, introduce regulations to amend the sex offender notification requirements so that those on the register are required to notify the police with details as to whether they have made an application for a gender recognition certificate. This will mean additional information will be available to help identify an individual and inform their subsequent management under the multi-agency public protection arrangements. This adds to the information that those on the register are already required to provide to the police, such as name, address and passport, so that the police are fully informed about information relating to the person's identity. This does not mean there is any implied link between trans people seeking gender recognition and sex offenders, but it will mean that Police Scotland will be informed of an application by someone on the register. This will allow them to take action, either in relation to the application itself, if necessary, or as part of the broader police role in managing the registered sex offender population. The action that Police Scotland could take, if they believe an application is fraudulent, would be to apply to a sheriff as a person with an interest for revocation of the GRC and/or work towards criminal prosecution under the offences in the bill. Under Scottish Government Amendment 60, the Registrar-General, if informed by Police Scotland, could reject such an application following a successful application to the Sheriff, meaning that the applicant would be denied a GRC. This means that it's possible to prevent someone on the Sex Offenders Register from fraudulently obtaining a GRC. In addition, and I don't want to anticipate discussion of a later group, but will also note that Jamie Green's Amendment 133 is relevant to these issues. I'll be supporting the principle of the creation of a new statutory aggravation to an offence in connection with fraudulently obtaining a GRC. Taken together, this is the right, proportionate and competent set of measures to put in place in this area, and on the basis of the action and the safeguards I've set out, I would urge the committee not to support any of the amendments in this group.
Thank you. Russell Finlay to wind up and press or withdraw Amendment 114.
Thank you, Convener. A number of points, and I think it's worth just repeating what I opened with and what the Cabinet Secretary acknowledged, which is this is not about trans people, this is about male offenders, sex offenders in the main. I welcome the commitment that's been given today to amend the sex offender notification requirements, which goes some way towards addressing this, albeit nowhere near enough. I don't agree with many of the Cabinet Secretary's views on this. I think the opening statement that there's no evidence of sex offenders having exploited GRC or being likely to is ill-judged and perhaps even naive. I think it's not just likely but inevitable. And I would be quite keen to know whether the proposed amendment, the mechanics of that, when this comes into being, what was proposed as a way of...
Cabinet Secretary?
Well, as I've said, it will be the Justice Secretary will put that into place before this bill is enacted, so in advance.
Mr Finlay?
Right, thank you. Well, that's reassuring. Yes.
Yeah, I thank my colleague for taking the intervention. And I think he put forward, a strong argument for the amendments that he was making. And I think regardless of whether, and we took evidence during committee, whether regardless we think these are plausible scenarios or not, I think what Russell Finlay has done is outlined that they could happen. And I also welcome the Cabinet Secretary's response in some of the actions that the government will take through Keith Brown. So what I wanted to ask Russell Finlay was if there's any, I don't know how he's now going to go with his amendments based on what he's heard, but if there's any scope for him and the government to discuss it ahead of stage 3, so that, because at this point I feel that his amendments are too raw and we don't know the full implications. The Cabinet Secretary suggested that some of them might be in a human rights context. So that would, I would say that at that point the committee should vote against these. But given that he has raised some concerns and there's a recognition that perhaps that some ground could be reached, I wonder if he's considering having further discussions ahead of stage 3 as opposed to pressing the amendments just now.
Thank you. I didn't hear anything really from the Cabinet Secretary suggesting an interest in discussing a common ground. I may have been mistaken, but I didn't hear that. I think that the supposed incompatibility of some of these amendments with human rights legislation is debatable, and I think it's important that we do move these. Before I do, I'd like to make one final point, which is that what's being proposed would be the equivalent of closing the stable door off after the horse is bolted. What my amendments do are preventative. They are about protecting women and protecting the criminal justice system from abuses in quite a common sense way, and therefore I would seek to move these amendments.
Okay, amendments are pressed. So the question is that Amendment 114 be agreed to. Are we all agreed? Yes. No, they are not agreed. We now move to a vote. All members who wish to vote yes, please raise your hands. All members who wish to vote no, please raise your hands. All members who wish to abstain. Did you get everybody? Okay, so that is yes 2 and no 5. The amendment is therefore not agreed to. Call Amendment 83 in the name of Ros McCall, grouped with amendments as shown in the groupings. I draw members' attention to the procedural information relating to this group as set out in the groupings. Point out that if Amendment 32 is agreed to, I cannot call Amendment 93, 57 or 58 due to a preemption. If 93 is agreed to, I cannot call Amendments 57, 58, 59, 33 or 34, again due to a preemption. If Amendment 99 is agreed to, I cannot call Amendment 72, also due to a preemption. Members should also note that Amendment 36 and Amendment 113 are direct alternatives. So, Ros McCall to move Amendment 83 and to speak to all amendments in the group.
Thank you. First of all, and to clarify to members of the committee, my amendments are probing ones to ascertain from the Minister her views on the principle of overseas gender certificate recognition. Therefore, I do not intend to push the amendments in my group, but I hope the Cabinet Secretary can provide some answers. Let me clarify for the committee that these sets of amendments do different things. One would remove the process of overseas gender recognition entirely, essentially meaning that we revert to the status quo position of a person having to obtain a gender recognition certificate through the process outlined in this bill, without any bespoke overseas recognition process. That's currently the case across the UK. Now, this Amendment 93 would in effect ensure that somebody moving to Scotland from overseas would not have any more or less rights than anybody residing currently in Scotland, and that is the important part. The intention of the other amendments in this grouping is to allow approved countries, in inverted commas, to have the process of overseas gender recognition, while everyone else will have to go through the process to obtain a gender recognition certificate. And this was to outline an alternative to the committee, rather than removing the overseas gender recognition provision from the bill in its entirety. However, as previously mentioned, I don't intend to push these amendments at this stage. As this bill is introducing a new process for overseas gender recognition, I think it's important that we get on record the Minister's view on the need for this provision and the safeguards that are required if it's to proceed into law. So, can I ask the Cabinet Secretary directly what the Scottish Government's justification is for introducing this new process of overseas recognition for gender certificates? Does the Minister agree that the current draft of the bill does not have adequate safeguards in the terms of preventing, bad actors from exploiting the overseas recognition provision as they currently stand? And is the Minister willing to strengthen the safeguards in this part of the bill, and does she see any merit in the proposed outlines on my amendments that she could support if technical drafting on them would be improved? Thank you.
So if I can just pause just now, the last vote on 114, I announced 2-5, but the correct vote was 3-4. So just to confirm, the vote on 114 was 3-4 and 4 against. Okay, thank you. Cabinet Secretary.
I don't support the amendments in this group in the name of Rose McCall, but I'm happy to continue to discuss ahead of stage 3 any further concerns that she may have. At present, overseas gender recognition is not recognised automatically in the UK. Persons who have obtained gender recognition overseas who wish to be recognised in the UK have to apply to the Gender Recognition Panel under its overseas track. The overseas track operated by the panel is used when a person has obtained gender recognition in what is called an approved country or territory, listed in a statutory instrument made by the Secretary of State after consulting with the Scottish Ministers and the Department of Finance and Personnel in Northern Ireland. This is a system that Rose McCall, I think, wishes to emulate, despite the fact that the present list of countries and territories maintained by the UK Government has not been updated for 10 years. It therefore features jurisdictions that have changed and updated their systems for gender recognition in that time, several of which are now based on similar models to that contained in this bill, and equally does not include countries that have introduced gender recognition systems, including our near neighbours, Ireland. Section 8(1) of the bill, which would be removed by these amendments, provides that where a person has obtained overseas gender recognition, they are to be treated as if they had been issued with a full GRC by the Registrar General for Scotland. So in broad terms, the bill's approach is similar to the current approach taken in Scotland for the validity of marriages entered into out with Scotland and recognition of divorce obtained overseas. It's a more straightforward and less convoluted approach than that proposed by Rose McCall. Automatic recognition would not apply, though, if it would be manifestly contrary to public policy to do so. For example, in a case where legal gender recognition was obtained overseas at a significantly younger age. So I therefore urge the committee not to support these amendments. Turning to the amendments in my name, Section 8 of the bill inserts two new sections, 8M and 8N, into the 2004 Act, which provides for automatic recognition in Scotland of a gender recognition certificate issued elsewhere in the United Kingdom and of gender recognition obtained overseas. Amendments 56 and 57 clarify that the automatic recognition ends if the gender recognition obtained elsewhere no longer has effect. Amendment 58 relates to cases where someone with overseas gender recognition of their male or female gender goes on to acquire recognition of a non-binary gender in their own country, for example, Denmark or Malta. The amendment provides that in Scotland their gender will not revert to being their gender at birth, but will continue to be the male or female gender they had previously acquired. These amendments are intended to cover specific eventualities in line with the general principles of the bill, and I would urge the committee to support them.
Okay, Ros McCall, to wind up and press or withdraw Amendment 83.
I'm sorry, I'd like to welcome the Cabinet Secretary's remarks. Thank you very much indeed for that, and I will accept the offer to work with you to improve the Government's amendments at stage 3. So therefore we'll support the amendments in this group.
Can I confirm that you want to withdraw?
I'm not pressing them. I'm going to withdraw. Yeah.
You want to withdraw. So the member is seeking permission to withdraw Amendment 83. Is that agreeable? Okay. I therefore call Amendment 2 in the name of Sue Webber, grouped with amendments as shown in the groupings. Sue Webber to move Amendment 2 and speak to all amendments in the group.
Yes, thank you, Convener. Good morning. And this group of amendments are regarding the retention of the current application process and evidence required in support of applications. So these amendments bring the legislation to the status quo, retaining and importantly retain current safeguards. They would mean that all of the existing provision about the Gender Recognition Certificate, the GRC, in the 2004 Act would be retained, so it would operate in the same way that it does now. The only difference would be that an application can be made to the Registrar General, but the application to the Registrar General would, with these amendments, still need the approval of the Gender Recognition Panel, so the effect would be the same. The aim of keeping the current legislation in place is to protect vulnerable young people from making life-altering decisions, while protecting women and girls from bad faith actors that might take advantage of these changes. Amendment 2 retains the Gender Recognition Panel specifically, as there is not enough evidence supporting the removal of the panel. And even though we recognise and acknowledge the issues some people have had with the panel, we believe that overall the panel provides a system of safeguarding and gatekeeping. We also believe that more evidence should be required before removing it, and currently there is just not enough evidence to suggest that the Registrar General alone should be responsible for the administration of the gender recognition certificates. Amendment 3, this retains the need for a medical diagnosis. A medical diagnosis of gender dysphoria can distinguish between bad actors. Women's Rights Network Scotland have told us that removing the requirement for a medical diagnosis could lead to an abuse of the system by bad faith actors, particularly predatory men that we've heard from colleagues earlier. My Amendment 4 retains the need for one to have lived for 2 years in the acquired gender, whilst also maintaining that the applicant be at least 18 years old. We believe that 3 months is too little time to take such an important decision. Distressed people can make lifelong decisions before medical professionals have had the chance to help them, especially when coupled with the lack of a gender dysphoria diagnosis. And we all know a lot can happen in 2 years, in particular when you're young and growing. The Scottish Government's decision to set a 3-month period is entirely arbitrary and lacks evidence. Furthermore, a 16-year-old is too young to obtain a GRC, and allowing them to make a life-altering decision after a short period of time could have negative consequences which are just not accounted for in the bill. The amendments 5 to 17 are all consequential amendments as a result of reverting back to the status quo. They remove sections, and there's a long list, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 and the schedule. This is necessary because of my first 3 amendments, which remove sections 2, 3 and 4 of the bill. They mean that all these subsequent sections of the bill are no longer required. For example, the sections on further provision about applications and certificates is void when the status quo is retained, because these sections are changing the provisions in the bill that I wish to remove. I hope that clarifies the position for the committee. And convener, this is not just my position. A poll has indicated that only a minority of Scots support removing these safeguards. Only 19% of Scots support reducing the age when one can obtain a GRC from 18 to 16. 25% support cutting the waiting period from 2 years to 3 months, and 26% support removing the requirement for a medical diagnosis. The current safeguards exist in law are important, and I, along with the majority of the Scottish public, recognise this and want them retained. I hope the committee agrees to these amendments. Thank you, convener.
Thank you. I now call Rachel Hamilton to speak to Amendment 26 and other amendments in the group.
Thank you, convener. My amendment seeks to retain the requirement to provide evidence to accompany an application for a GRC. It would specifically retain sections from the 2004 Act, ensuring that legitimate concerns of parents, young people and gender identity experts regarding the removal of safeguards are addressed. The GRR bill would remove the requirement for medical evidence and reduce the period that applicants must live in their acquired gender before applying for a GRC from 2 years to 3 months. The Scottish Government want a system for legal gender recognition based on a statutory declaration and not a gender dysphoria diagnosis. I'd like to ask the Cabinet Secretary if she can cite evidence from other countries where the impact of reform has been evidential from these emerging policies. And can she also comment on the prediction that removing a gender dysphoria diagnosis will not extend GRCs to a much larger and diverse group, such as predatory men? How will vulnerable individuals be supported without medical support? How will undiagnosed conditions be picked up? What evidence does the Scottish Government have that dropping the requirement to provide medical evidence is best for everyone? Surely that stance point is entirely subjective. Finally, why does anyone without gender dysphoria need to change their sex in law? NHS guidance says social transition should only be considered where the approach is necessary for the alleviation of or prevention of clinically significant distress or significant impairment in social functioning, and the young person is able to fully comprehend the implications of affirming a social transition. Doctors caring for youngsters distressed about their gender have been told that this is not a neutral act to help them transition socially by using their preferred new names or pronouns. The draft guidelines say doctors should carefully explore underlying health problems, including mental ill health, amid concerns that the NHS is rushing children onto irreversible puberty blocker medication. A significant proportion of children and young people who are concerned about or distressed by issues of gender incongruence experience coexisting mental health, neurodevelopmental and or family or social complexities in their lives. A number of doctors, including Dr Anthony Latham, Chair of the Scottish Council on Human Bioethics, Dr Anne Williams, Vice Chair of the Scottish Council on Human Bioethics, and Dr Callum McKellar, Director of Research at the same institute, said, unfortunately, the Stage 1 report on the Gender Recognition Reform Scotland Bill, which was published by the Human Rights and Civil Justice Committee of the Scottish Parliament on the 6th of October, has not sufficiently considered the evidence of mental disorders, which are often present with gender dysphoria. As a result, the recommendations given by the majority of MSPs preparing the report are unsafe and should be rejected. In summary, the majority position in the report from the Human Rights and Civil Justice Committee is unworthy of the high expectations of the Scottish Parliament and the Scottish people, since it is unreasonable, unprofessional and does not sufficiently address the biomedical evidence. Moreover, as the Scottish Parliament does accept the majority view of the committee in removing the requirement of a medical opinion before gender transitioning takes place, this will lead to some young persons being harmed. Moreover, research shows that many children with gender dysphoria have significant psychological and physiosocial vulnerabilities. Thus, without a medical appraisal, it is very unlikely that many young persons may embark on risky life-changing procedures which they do not understand. And this is all more concerning since follow-up studies indicate that overall the distress experienced by young people affected by gender dysphoria disappears in about 85% of cases either before or early in puberty, though the rates in studies vary widely. With regards to living in the acquired gender, 3 months is too short a time for such a life-changing decision, especially for 16 and 17-year-olds who are going through significant changes such as puberty and exams. Furthermore, living in the acquired gender for just 3 months without a diagnosis of gender dysphoria may not be enough time for an individual to seek medical help or support with mental health if needed. It appears that many stakeholders are concerned that clarity is required over what living in an acquired gender even means. 2 years provides sufficient safeguarding. Thank you.
Thank you. And Maggie Chapman.
Thanks very much, Joe. It may surprise colleagues that I want to speak in this grouping, but I will be supporting Amendment number 14. Taken on its own, Amendment 14 removes the specific criminal offence introduced by the bill of making a false declaration in relation to one's trans status. We heard from several people and organisations in evidence sessions, the Children's Commissioner, Amnesty International, Just Right and Engender, that this specific offence is unnecessary. It already is a criminal offence under the Criminal Law Consolidation Scotland Act 1995 to make a false statutory declaration, and the introduction of a new offence risks unnecessarily criminalising children. But there is another reason not to have this offence. Having a specific offence that names trans people specifically potentially makes an already marginalised and vulnerable group more of a target for litigation. So for very different reasons to Sue Webber and from a very different place of principle and value, I will vote in favour of the removal of section 14 from the bill. Thank you.
Okay. Fulton McGregor.
Thanks, Convener. I just wanted to speak briefly on these amendments put forward by Sue Webber and Rachel Hamilton. I mean, as I said in previous interventions, I think that stage 2 will allow us to find a lot of compromise, and I will still take this opportunity before he presses the other amendments later on for Russell Finlay to work with the government. But in this particular area, I think, you know, this is the core of the bill that we're talking about here, and some of the evidence that we heard in committee about needing, you know, basically medical permission for people to be who they are is really, you know, against the grain of the bill. And I won't get into the whole debates around the 3-month period, because I know, Convener, that time is tight, and that those issues have been debated quite thoroughly. But in terms of the process for an application, I can't agree with these amendments at all. I do think that they go to the core of the bill, and the purpose of this bill is to make life better for trans people, and we've got to keep that at the core. And while I really do want to find compromise as we move forward through this bill, and I know the government do as well, I cannot support these amendments.
Okay, thank you. And Pam Duncan-Glancy.
Thank you, Convener. Similarly to my colleague Fulton McGregor, I would just like to put on record that we will be voting no to the amendments in this section today on the basis that they undermine the purpose and principle of the legislation we are trying to discuss today. We will be voting against Amendment 2, 3 to 17 and 26.
Okay, thank you. And Cabinet Secretary.
Thanks, Convener. The effects of Amendments 2 to 17 in the name of Sue Webber are obviously not in keeping with the general principles of the bill, as agreed to by the majority of this committee and a clear majority of the Parliament at stage 1, including members of all parties. Amendment 26 in the name of Rachel Hamilton presumes that Sue Webber's amendments would be passed, and it would remove the requirement for medical reports submitted to a gender recognition panel to include details of treatment for the purpose of modifying sexual characteristics which the applicant has undergone, is undergoing or has been prescribed or planned for them. The other requirements relating to medical reports in the 2004 Act would remain. Rachel Hamilton had asked a question about international evidence, and just briefly to point out that the committee itself looked at this, and I think one of the people giving evidence to the committee was the United Nations independent expert on protection against violence and discrimination based on sexual orientation and gender identity, and they gave evidence that some of the theoretical concerns that were raised in the process of adopting those processes have not materialised in the countries, the numerous countries that have implemented similar systems. And of course, the committee's report noted that the majority recognised that when asked about evidence of abuse and concerns, that there was no witness was able to provide concrete examples. I'm quoting from the committee's report directly. So I think in short, the Parliament has shown their support for the principles and purpose of the bill, which, as shown in the long title of the bill, aims to reform the grounds and procedure for obtaining gender recognition and for connected purposes. So I would urge members to vote against these amendments.
Thank you. And Sue Webber to wind up and press or withdraw Amendment 2.
Thank you, Convener. And yes, I'd like to make reference to particularly the comments from Fulton McGregor and also the Cabinet Secretary regarding what the comments about these series of amendments being against the principles of the bill. We too want to safeguard and make sure people that are trans people can go through this process in as much streamlined and secure way possible. We do not want to make life more challenging for these people. And I want to make that clear. I think a person can go through a range of life experiences in 2 years, as I mentioned, schooling, changes to family and moving to different parts of the country, puberty to name but a few. And I think having the safeguards in place will make sure that the right decisions are made. These are life-altering decisions that these people can be taking. They are not reversible. And I think that is something we need to look long and hard at. Given the comments that we've had and the feedback from discussions with my colleagues as well, I think today I will look to only press Amendment 2, Convener. And with that, I'll conclude my comments.
Thank you. And the question therefore is that Amendment 2 be agreed to. Are we all agreed?
No.
That is not agreed. So all those who, all members who wish to vote for, please raise your hands. All those against, please raise. And I think there are no amendments. No abstentions, sorry. Okay, so that is 2 for and 5 against with 0 abstentions. The amendment is therefore not agreed to. I call Amendment 84 in the name of Ros McCall, already debated with Amendment 83. Ros McCall to move or not move? Not move. Not moved. I call Amendment 85 in the name of Ros McCall, already debated with Amendment 83. Ros McCall to move or not move?
Not move.
Thank you. I call Amendment 115 in the name of Pam Duncan-Glancy, grouped with Amendment 116. Pam Duncan, sorry. Sorry, but just take a...
That's the beginning of the next group.
Yeah, sorry, where am I? There's an issue in my... Here. So there's a bit missing, yes. Sorry, 115, this one will be moved. Spoken to.
It's fine, just keep going.
Just keep calling in 115. Okay, calling in 115 in the name of Pam Duncan-Glancy, grouped with Amendment 116. Pam Duncan-Glancy to move Amendment 115 and speak to both amendments in the group.
Thank you, Convener. Yep. I have brought this amendment because I don't think it's fair to exclude asylum seekers from the process. My amendment explicitly adds them to the bill, and I'd encourage members to vote for Amendment 115 in my name for that reason. Thank you.
Thank you. And Tess White to speak to Amendment 116 and other amendments in the group.
Thank you, Convener. The Equalities, Human Rights and Civil Justice Committee's Stage 1 report highlighted that there is uncertainty among stakeholders about what ordinarily resident means in practice. Amendment 116 seeks to clarify from the Scottish Government what it means to be ordinarily resident in Scotland for the purpose of obtaining a gender recognition certificate. The intention is to provide clarity, but also a safeguard to prevent the potential for GRC tourism. The explanatory notes for the Gender Recognition Reform Bill states the term ordinarily resident is not defined by the bill and thus takes its normal meaning. That normal meaning
is determined largely by case law and specifically the Shah test. The policy memorandum for the bill suggests that a person is ordinarily resident in a place if they have lived there on a settled basis, lawfully and voluntarily. But it also states that whether a person is ordinarily resident in Scotland will depend on their individual circumstances. While the Scottish Government has emphasised that the concept is used in 17 acts of the Scottish Parliament, as well as UK legislation, it's clear the term is not understood more widely. In her evidence to the committee, I note that human rights lawyer Jen Ang with Just Right Scotland, which I understand is partly funded by the Scottish Government, emphasised that, and I quote, the term ordinary resident is used differently in different parts of legislation. So when it is included in a piece of legislation, it is important to define what it means specifically. It is not even to avoid unintended consequences. It is just to make it clear to everyone who is physically in Scotland whether the procedure is available to them. In Ireland, where self-ID has been in place since 2015, ordinary residence is also used to determine eligibility for applying for a GRC. However, the definition of ordinarily resident in Ireland is that you have been living in Ireland for at least a year, or you intend to live here for at least 1 year. My amendment mirrors that approach, and I would be grateful if the Minister could indicate whether such an approach was considered when the bill was being drafted. I further note that the Student Awards Agency Scotland website states that the Scottish Government expects someone who is ordinarily resident in Scotland to have made their home in Scotland with the intention of staying and living here, and not just to undertake a course of study. I will briefly address Pam Duncan-Glancy's Amendment 115, which attempts to clarify the definition of ordinary residence in relation to refugees. I know the committee considered this issue during the evidence it took on the bill and sought further clarity from the Scottish Government. I am supportive of Pam Duncan-Glancy's policy intention in this area. I urge the committee to consider defining ordinarily resident on the face of the bill so that it is clear from the outset who is able to apply and to prevent the potential for misuse. And finally, committee, the concept of ordinary residence engages the question of fact and degree as well as intention. The fact that the Scottish Government has chosen not to define ordinary residence on the face of the bill at the outset doesn't prevent it doing so now. I suspect that the Government has pursued the approach it has on this concept so that a great deal will go into guidance or its equivalent, which MSPs are enabled to scrutinise during the parliamentary passage of the bill. As such, I will press Amendment 116. Thank you.
Okay, thank you. And I call Rachel Hamilton.
Convener, I just want to thank Pam Duncan-Glancy and Tess White for their very constructive amendments. We are happy to support asylum seekers being introduced into this measure, as asylum seekers can be classified ordinarily resident in Scotland. I would also urge members to support my colleague Tess White's amendments, which would strengthen the definition of ordinarily resident to provide clarity for everyone, including asylum seekers.
Thank you. And Cabinet Secretary.
Thanks, Convener. The Committee Stage 1 report asked for clarity on the phrase ordinarily resident in Scotland, and we did provide that in our response. For today's purposes, I will therefore reiterate again that ordinarily resident is an established concept within several areas of law, and as Tess White herself indicated, is used in at least 17 acts of the Scottish Parliament and many more UK acts. This includes Section 3C of the 2004 Gender Recognition Act, which in relation to Scotland enables certain persons to apply under an alternative track for a GRC if they are in a marriage solemnised in Scotland or a civil partnership registered in Scotland. One of the conditions for such an application is that the applicant is ordinarily resident in Scotland. Amendment 115, in the name of Pam Duncan-Glancy, seeks to include a person who is seeking asylum in Scotland within the definition of ordinarily resident. And let me begin by saying I'm, of course, very sympathetic to the concerns expressed during stage 1 about the potential that asylum seekers living in Scotland might not meet the requirement of being ordinarily resident. But an asylum seeker does not seek asylum in Scotland, but in the UK through immigration laws that are reserved. As I've just said, ordinarily resident is an established concept in law, and it is the case that under the UK asylum and immigration system, some asylum seekers may not meet the test of being ordinarily resident. In addition, asylum seeker applicants who are not ordinarily resident in Scotland and who have not been born in Scotland have a tenuous connection with this jurisdiction, which raises a competence issue. There is also case law which has confirmed that a failed asylum seeker is not ordinarily resident because they do not meet the requirement that residence must be lawful. I've highlighted the committee's comments about asylum seekers in correspondence to UK ministers and await their reply. I would also like to say that there is still a route open to asylum seekers to gain legal recognition. Whilst they may not meet the residency criteria within our process, they may be able to apply under the 2004 Act, as it would apply in the remainder of the UK, as it does not specify a requirement for ordinary residence within the UK. Therefore, unfortunately, I must ask the committee not to support this amendment for these reasons. I'll now turn to Amendment 116 in the name of Tess White, which seeks to strictly define the term ordinarily resident in Scotland as being limited to those persons who have been living or intend to live in Scotland for a minimum period of 1 year. Having an intention to live in Scotland does not satisfy those tests to be ordinarily resident. Tess White's aim to redefine the term go beyond the criteria established in law against which an individual's circumstances are assessed for whether they are ordinarily resident, namely that their residence is here is voluntary, for settled purposes and lawful without any necessary period of time having to be established. So for these reasons, I urge the committee not to support this amendment.
Thank you. And Pam Duncan-Glancy to wind up and to press or withdraw Amendment 115.
I thank the convener for that, and I thank the Cabinet Secretary for her answers. And I note concerns around some of the competency of this, but I believe that we do need to send a signal that asylum seekers are welcome to apply for this process. And I wonder, therefore, if the Cabinet Secretary would consider that in Tess White's Amendment 116, where the requirement is that they intend to be here for longer than a year, I would imagine most asylum seekers would make that declaration and believe it to be true at the time. And on that basis, would the Cabinet Secretary consider supporting that amendment?
So I think in response to Pam Duncan-Glancy, the issue is less about that and the basis of which asylum seekers are here in Scotland and the fact that they are here under immigration legislation. What I would be prepared to do is to work further with Pam Duncan-Glancy to see if there is a way to work through this and perhaps to try and elicit a response from the UK Government in advance of stage 3 to be able to discuss this further to see if there is anything we can do within the competency of this bill if Pam Duncan-Glancy was minded not to press at this stage.
Thank you, Cabinet Secretary, and I appreciate that. I'm tempted to press at this stage because I want to put it on the record the strength of feeling for asylum seekers to be included in the bill. But I also would welcome discussions further at stage 3, particularly if this particular issue isn't addressed in the committee today.
Sorry, was that to press?
Yeah, I therefore do press this amendment.
Okay, thank you. So the question is that Amendment 115 be agreed. Are we all agreed?
Yes.
Okay, that is not agreed. All those in favour of 115? Okay. And all those against? And abstentions? Okay, so that is 4 votes for and 3 votes against. The amendment is therefore agreed to. I now call Amendment 116 in the name of Tess White, already debated, with 115. Tess White to move or not move.
I move 116, convener.
Okay. So the question is that 116 be agreed to. Are we all agreed? No. So we'll go to a vote. All those who wish to vote for, please raise your hand. And palms, yeah. All those against? Okay. That is 3 for and 4 against. The amendment is therefore not agreed to. Call Amendment 86 in the name of Ros McCall, already debated, with Amendment 83. Ros McCall to move or not move.
Will not move.
Thank you. Question is the question is that Section 2 be agreed to. Are we all agreed? Yes. That is agreed. Call Amendment 117 in the name of Carol Mochan, already debated, with Amendment 18. Carol Mochan to move or not move.
Not moved. Thank you, convener. Not moved.
Call Amendment 87 in the name of Maggie Chapman, grouped with Amendments 88, 89, 91 and 141. And I draw members' attention to the procedural information relating to this group as set out in the groupings. Point out that if Amendment 91 is agreed to, I cannot call Amendment 121 due to a preemption. Maggie Chapman to move Amendment 87 and speak to all amendments in this group.
Thanks very much, Joe. I've made no secret of my opposition to any waiting times for the GRC application process. As we have heard repeatedly in evidence, the 3-month periods of living in the acquired gender before an application and 3 months reflection period following an application before it is granted are arbitrary, unnecessary and unusual. I'll start, though, with the last amendment in this group, Amendment 141, as I appreciate I'm unlikely to attract cross-party support for abolishing both the time periods completely. Amendment 141 calls for a review of the impacts of these time periods on trans people themselves. If we retain the time periods in any form, we do so knowing that we are going against international best practice and against the advice and guidance of trans people and the organisations that directly support them. So we should put in place a clear mechanism for reviewing the impacts of these time periods on trans people themselves specifically. And that is what Amendment 141 does. But on the other amendments in this group, 87, 88, 89 and 91, these come from a position of principle that we should recognise the autonomy of trans people and that they know their own minds. Changing one's legal gender is not something that one does on a whim. Indeed, the discussions we have had and will have about ensuring the gravity of making such a statutory declaration is understood make that even clearer. Changing one's legal gender is not done lightly, and those applying for a GRC will likely have thought about, considered and reflected upon this decision for months, if not years, before they get to the point of putting in an application for a GRC. And they are likely to have completed many other aspects of their transition over the course of several months or years before applying for legal gender recognition. Having spoken to young trans people themselves, as Dr. Mary Crawford of LGBT Youth Scotland does regularly, she said in a committee evidence session that young people tell us that before they come out, they have already done an awful lot of reflection to understand their true gender. Then they come out, usually to a safe group, and they build up from that. By the time they look to apply for a gender recognition certificate, they have been living in their acquired gender for quite some time. Only Belgium and Denmark have a reflection period in place. We heard evidence that in Denmark, where there is a 6-month reflection period, the trans community consider it patronising and were unsure of what they should be reflecting on. Having listened to trans people, there are now plans to remove this reflection period completely. If we are trying to give trans people more agency and autonomy over their legal gender status in this bill, it seems completely counter to this intention to impose another standard of authority by imposing a waiting period on them. We are telling trans people that we don't believe them when they tell us who they are. We are telling trans people that we don't think they do know their own minds. We should not be doing that. I urge my committee colleagues to assert that trans people do know their own minds and support my amendments. Thank you.
Thank you. And Rachel Hamilton.
Thank you, Convener. Given that I have submitted amendments which intend to increase the period in which someone must live in the acquired gender to the status quo, I not only believe that the current proposal by the Scottish Government of 3 months is inadequate, but the absence of any reflection period could lead to young and distressed people rushing into life decision changes that they may later regret. This is especially true if it is coupled with medical alterations such as hormone, puberty blockers and surgery. Furthermore, a reflection period could prevent so-called bad faith actors from taking advantage of these changes and intruding into single-sex spaces. Weakening the provisions in this bill would make it even worse, and so I cannot support amendments 87, 88 and 89. However, I am happy to support 141 because I believe it is important that the Scottish Government reviews the period in which a trans person is required to live in the acquired gender, although I know Maggie Chapman wishes to lower the period of time and I want to raise it. I think we can both find common ground that reviewing the evidence will allow for a more informed decision from the Scottish Government to be made in the future. Thank you.
Thank you. And Pam, were you? Oh, Christine Graham.
Thank you, Convener. Can I say to Maggie Chapman, I agree the majority of people do know their own minds, and many, and I've met them, have been living in a different gender for a long time before they would ever apply for gender recognition. But it's the majority, you're saying. But there are other people who will be transitional, who will have to have a period of thought about it. And I'm looking at the balance. That is those who already know, and they won't, if they've already been living in that for years, the 3-month period will be nothing to them, because they can demonstrate they've been doing it for years. Same with the 16 and 17-year-olds for 6 months in advance, and the reflection period. But there are people for whom I want to just have a little safeguard, particularly 16 and 17-year-olds. And in no way does that take away from the autonomy of individuals. I met parents of a child of 10 who knew they were really a girl. And he transitioned to she at primary. So I've been talking to people in both directions about this before I came with these amendments. So what I'm looking for here in law is something that works for as many people as possible and provides safeguards. So that's the only reason I would say to Maggie Chapman, I think we can't take away all protections and just say that, or safeguards. Thank you.
Thank you. And Cabinet Secretary.
Convener, let me begin by saying I know these amendments reflect the views of Maggie Chapman that the time period for living in your acquired gender as well as the reflection period should be removed, and this is a position taken by her throughout the passage of the bill and in our discussions on the matter, and of course I respect that, just as I do the other views expressed during the passage of the bill, even if I don't agree with them. I note there are views that the time period should be longer or removed entirely, or the reflection period should be removed, but usually with an increase in the time period for living in the acquired gender. I've not seen an alternative to our proposals that would be accepted and keep to the principles of reforming the process. I consider the current requirement for applicants to provide evidence that they have been living in their acquired gender for a period of 2 years before applying to be unnecessarily long. A reduction in the time period to 3 months, followed by the 3-month reflection period, represents a review of a balanced and proportionate way of improving the system, and obviously 6 months of living in the acquired gender for 16 and 17-year-olds if Christine Graham's amendments are accepted. I have, however, considered that the reflection period could be a disproportionate barrier to people in the circumstances that they are at the end of life, and appreciate that an important benefit of legally changing your gender is ensuring that your death is registered in the gender in which you lived, and that's why I have lodged an amendment to the bill so that an applicant at the end of life can apply for a dispensation from the 3-month reflection period, which will be taken in a later grouping. So for those reasons, I cannot support amendments 87, 88, 89 and 91. However, I do agree with Maggie Chapman that it will be important to keep this under review. There are, of course, several amendments that have been lodged to review and report on the operation and impact of the bill across a number of areas that we'll get to later this session. This one, within this group, I'm happy to support and would urge the committee to support. It will be necessary for us to consider carefully what is possible and appropriate for us to gather information and data about, and the impact of the time periods on trans people going through the application process is certainly an area that we can take forward. I therefore support Amendment 141 in principle, but would look to work with Maggie Chapman and other members ahead of Stage 3 to ensure that any report and review amendments agreed at Stage 2 coalesce around the same time frame.
Okay, thank you. Maggie Chapman to wind up and press or withdraw Amendment 87.
Thanks very much, Joe. Just a few comments. Just for clarity, Rachel Hamilton talked about medical procedures and therapies. Just to be clear, this has got nothing to do with an application for a gender recognition certificate. No medical process is required or expected as part of the gender recognition application process, and no GRC is required to undergo any medical transition. On Christine Graham's comments, I do believe that you are sincere in your endeavours, in her endeavours and her position on this issue. I think we just fundamentally disagree how we come at that. And finally, I thank the Cabinet Secretary for her comments and for the many interesting and helpful conversations we've had on this and other issues in this bill over the last many months. I acknowledge her comments about the amendment we'll come to later about provisions for end of life, and I thank her for those, and I also thank her for her comments about my amendment 141. But I will be pressing my amendments that seek to remove the 3-month living in the acquired gender period and the 3-month reflection period. Thank you. So I will press Amendment 87.
Thank you. So the question is that Amendment 87 be agreed to. Are we all agreed? No, yes. No, that is not agreed. All those in favour of Amendments 87, please raise your hand. And all those against? Okay. Okay, that's 1 for, 6 against. That amendment is therefore not agreed to. I call Amendment 88 in the name of Maggie Chapman. Already debated with Amendment 87. Maggie Chapman to move or not move?
Move.
Is that agreed?
Yes.
Okay. All those in favour of Amendment 88, please show. And all those against? Okay, that is 1 for and 6 against. The amendment is therefore not agreed to. I call Amendment 38 in the name of Christine Graham, already debated with Amendment 18. Christine Graham to move or not move?
Moved.
The question is Amendment 38 be agreed to. Are we all agreed?
Yes.
I think I hear some no's. Yep. Okay, so the question is Amendment 38 be agreed to. Are we all agreed? Sorry. all those in favour, please raise your hand. Okay, and all those against? And abstentions? 1. Yeah. Okay, the vote is 3 for, 3 against and 1 abstention, and I will cast my casting vote for. The amendment is therefore agreed. So for.
Can I get clarification on that?
Sorry.
I thought you said 3 for. If it
3. Oh, sorry. 3 for,
right.
3 against. Sorry.
Right.
Apologies.
Thank you.
3 for, 3 against, 1 abstention. I will therefore use my casting vote to vote for, and so therefore the amendment is agreed to. I call Amendment 89 in the name of Maggie Chapman, already debated with Amendment 87. Maggie Chapman to move or not move?
Moved.
Okay, the question is that Amendment 89 be agreed to. Are we all agreed? No. It's not agreed. All those in favour of the amendment, please raise your hand. And all those against? So it's 1 in favour, 6 against. The amendment is therefore not agreed to. I call Amendment 3 in the name of Sue Webber, already debated with Amendment 2. Sue Webber to move or not move? Is anybody else moving it? No. Not moved. Okay. So the question is that Section 3 be agreed to. Are we all agreed?
Agreed.
That is agreed. I call Amendment 39 in the name of Christine Graham, already debated with Amendment 18. Christine Graham to move or not move?
Moved, Convener.
The question is that Amendment 39 be agreed to. Are we all agreed?
No.
That is not agreed. All those in favour, please raise your hand. All those against? And amendments? Abstentions? Sorry. 1 abstention. So that is 3 for, 3 against and 1 abstention. So again, I will use my casting vote. So the amendment is agreed to. The question is, I call Amendment 40 in the name of Christine Graham, already debated with Amendment 18. Christine Graham, to move or not move?
Moved.
The question is that Amendment 40 be agreed to. Are we all agreed? No. That is not agreed. So we'll go to a vote. All the members who wish to vote for, please raise your hand. All those against? Abstention? That is again 3-3-1. So I therefore use my casting vote to vote for. So the amendment is therefore agreed. Call Amendment 41 in the name of Christine Graham, already debated with Amendment 18. Christine Graham, to move or not move? The question is, Amendment 41 be agreed to. Are we all agreed? No. So we go to a vote. All members who wish to vote for, please vote. Please raise your hand. All those against, please raise your hands. Abstentions? Thank you. Again, that vote is 3 for, 3 against, 1 abstention. I'll use my casting vote for, and the amendment is therefore agreed to. I call Amendment 118 in the name of Russell Finlay, already debated with Amendment 114. Russell Finlay, to move or not move?
Not moved.
Not moved. I call Amendment 119 in the name of Russell Finlay, already debated with Amendment 114. Russell Finlay, to move or not move?
Not moved.
The question is that I call Amendment 120 in the name of Martin Whitfield, already debated with Amendment 18. Martin Whitfield, to move or not move?
I'm grateful, Convener. Given the indications from the Government, I'll not move at this stage.
Thank you. That's not moved. I therefore call Amendment 42 in the name of Christine Graham, already debated with Amendment 18. And I remind members that if Amendment 42 is agreed to, I cannot call Amendment 19 because of a preemption. Christine Graham, to move or not move?
Moved.
That is moved. So the question is that Amendment 42 be agreed to. Are we all agreed?
Yes. No.
That is not agreed. We therefore move to a vote. All members who wish to vote for, please raise your hand. All those who wish to vote against, please raise your hand. And abstentions? Yep. Okay, that's 3 for, 3 against and 1 abstention. So I'll use my casting vote to vote for, and the amendment is therefore agreed. So we therefore move straight to Amendment 90 in the name of Ros McCall, already debated with Amendment 83. Ros McCall, to move or not move?
Not moved.
Not moved, thank you. Call Amendment 43 in the name of Christine Graham, already debated with Amendment 18. Christine Graham, to move or not move?
Moved, please.
Question is that Amendment 43 be agreed to. Are we all agreed? That is not agreed. We therefore move to a vote. All members who wish to vote for, please raise your hands. No, it's just 3. All those against? And abstentions? Okay, that's 3 for, 3 against and 1 abstention. I therefore use my casting vote to vote for, and the amendment is therefore agreed to. I call Amendment 91 in the name of Maggie Chapman, debated with Amendment 87. Maggie Chapman, to move or not move?
Moved.
As Amendment 91 would preempt Amendment 121, I will not put the question on Amendment 91 until Amendment 121 has been debated. That said, we've come to a natural break, and so... Sorry. Yep. There's no points of order, but...
Oh, okay.
Do you want to make a point?
Yes, I would appreciate that. It's been noted on social media that a member of the public who was present was wearing a scarf in the colours of purple, white and green, and has been asked to either remove the scarf or leave the room. Can I seek some guidance?
I'm going to suspend the meeting. We'll have a discussion about this in private. We're suspending the meeting and we'll discuss in private.
as to why this happened.